meeting. This is a guide for families with someone who is on an LPS conservatorship. Next slide. So it's being presented by NAMI Urban Los Angeles. Today's presenters are Shaylin Saxton, who's from the Department of Mental Health Public Guardian's Office, Gail Evangueletti, and myself, Jim Farrell. Gail, of course, primarily focuses on the Los Angeles area. She's been involved in Los Angeles and knows everybody and just about everything that goes on, and has just a wealth of resources for everybody. And I'm pretty much doing the same thing over here in Orange County. I have a conservator assistance group, and I have families that call me in crisis, and we try to connect them to services. So let's get started. Araceli, if we can start the next slide, please.
Jim, we
Yes.
need to introduce Shaylin.
My apologies. Yes. This is Shaylin. I guess for some reason my screen isn't showing all of Shaylin's face. I don't know what I'm doing wrong. Maybe I just have it on the wrong deal here.
Or maybe when I speak. Yeah, good afternoon, everyone. My name is Shaylin Saxton. I'm joining from Los Angeles County Office of the Public Guardian this afternoon. Thank you.
So we're really happy that you've joined us, because before the meeting, we've already learned so much from you. And so this is so great that you're here to help us through this. Don't hesitate to speak out if we say anything that's not quite accurate or needs a little bit of extra information. Please do that. So we also want to thank Maddie Cobbs, Harold Turner, who is the director of NAMI Urban Los Angeles, and of course Araceli Hernandez, who is, as I mentioned, is behind the scenes making all this possible for today's meeting. So thank you all, just really great. We want to share also that Gail and I have learned, how to present this material from others. We are not attorneys. We basically share what we've learned and give the greatest probability of success for recovery for your loved ones. We make suggestions, and then of course you will be the one to determine the direction that you pursue. And of course we present the laws that should help guide your decisions. Again, we don't give lawful advice. We're not attorneys. But most of the information today pertains to Los Angeles County. However, all the information that we have to present is based on the Welfare Institution Code that was drafted some 50 years ago. And it's a law that must be complied to. But every county is under the same umbrella of this law called the Welfare Institution Code. Their attorneys within that county, like from their county council, may interpret it slightly different, but it is all pretty much exactly the same from county to county with some variances. So thank you again for everybody coming. If we can move on to the next slide, please. So one of the things, this is a tip for you as a conservator. Anytime that you have to deal with any agency in regards to your conservatee, you always want to refer yourself as the conservator. I'm Mary Jane's conservator. I'm Tommy's conservator. Don't say, oh, I'm Harold's mother or whoever's, you just don't go down that path. It gives you a greater degree of credibility when you are presenting yourself as the conservator. The other thing too is that we highly recommend that you take the free NAMI family to family classes that NAMI Urban Los Angeles provide. Of course, I guess if you're out of county in today's thing and you have your own county, you want to give your own NAMI lots of support as well. The other tip is that you need to keep a journal, not one, but two. One is going to be for your medications. You want to keep a track of what medications have been prescribed by your conservatee's doctor. And you want to also keep tabs on how effective those seem to be working. You also want to keep a log of the observations of how those medications are working. And you want to keep also close track on the people that you spoke with, whether you're calling the hospital or you're calling the services that are offered to your loved ones. Who did you talk to? What did they say? Just all that will be very, very important information that you can rely on if something were to come up. So get involved, get involved with your local NAMI, get involved with NAMI Urban Los Angeles if you're in LA area. It's a great organization to get involved in and you're going to benefit highly from it. Also, NAMI California has a lot of political efforts in the state of California. And so get involved with any legislative areas that you can, because it's when the families stand up and make their voices heard to our legislators that we can make a change and a difference. Okay, so next slide.
Well, can I just say something on that? When you're keeping the journal of your loved one, their medications, write down what they say, even as they're getting along the road to recovery. I mean, you don't have to write down everything, but when they say things, don't correct them. When you start correcting them, they clam up and they won't tell you things. So if you just listen to them, or if you really are concerned about what they're saying, you can say, well, that has to make you a bit uncomfortable. It would make me uncomfortable if I felt that way or saw that way. But keep in mind, when they're telling you something, that is their reality. This is your only way to know where they are in their recovery. And you don't want them to stop talking with you. You want them to keep those lines of communication open. Also, when you're writing down the second journal, people are going to tell you things that aren't true. And it's important to put down the date, the time, who you spoke with, and their contact information. And you can call me or Jim, and we will help you to get this corrected. We've corrected a lot of things that people have told, that they instruct people on that aren't true. And it's important to keep correcting this for people, because otherwise there's so many myths that they've spread around that are really not true. We don't want people fired because we really need these people in the community, but we do want them to be corrected on what they're telling you. So, and it doesn't hurt to say, let me understand what you're saying. You're trying to tell me that, this hospital doesn't do conservatorships, or we have to discharge the patient right away. You're going to know the laws pretty good, that you will know whether they're telling you the truth or not. Okay, next slide.
So LPS conservatorship, I do have a note on the previous slide when you're writing everything down. I would also take it a step further and write down what the medications are for, if there's any major side effects, so you'll know to have an eye out for those things. You kind of want to know and understand what each medication targets.
That's good.
Yeah. And then, so LPS conservatorship, it's a term used in California for involuntary mental health treatment. It's called guardianship or various other names in other counties and in other states, but every state and county does have some form of involuntary mental health treatment with a legal process. So here in LA County, it's conservatorship. And it's named after the LPS, and it is Lanterman Petrus in short. Those were the legislators. So it's with the Mental Health Care Act of 1967. So they wrote it, everything's named after them, LPS. The laws are in the California Welfare and Institution Codes, 5200, and it goes down to several series. So you'd be able to Google those if you wanted to look and read in how legally someone can be conserved in LA County. These are the laws, and this is the institution codes that we follow to make it technically be able to happen, right? The laws are older. and they may not really reflect what the doctor and treatment team may be telling you and what you're seeing, because conservatorship is a legal process. So how a judge sees it may be very different than how the treating psychiatrist or the psychologist who are counseling your loved one may see everything. So just kind of keep that in mind when you're trying to line everything up and see how everything is going as far as getting the best treatment for your loved one. And then the laws have been revised, but won't take place in Los Angeles and Orange County until January 1st of 2026. So what that means is there's a definition of what someone can be conserved under, but it has been expanded. And we'll talk more about that in some slides later. I'll be able to give you some more specific examples of how the law is changing, especially in LA County, January 1st. Next slide, please.
Okay. When you get your conservatorship, there's a booklet that they give to conservators if you're at court. If you're not at court and you're doing it through WebEx, it's found on the internet. And you might want to take that down. It really is a very good book because there's certain things in there. It talks about the renewal of the conservatorship. It talks about your rights. If your loved one needs to be able to drive a car, they can get the right to drive a car back. And it's got the form in there. It has a lot of forms, but it's one of the best things that you can get. It's called Helping Your Loved One, A Family Guide to Conservatorship and Involuntary Treatment. So that's something to take into consideration. Shaylin, do you want to add anything on that?
Yes, and just kind of it is renewed every few years or so. I think we're up to maybe the 8th or 10th edition now. And there are other like pamphlets and things linked to that site that are helpful. And it kind of just helps you navigate and has some added notes and everything of what you as conservator, what your rights are and what you can do. You know, if you need a refresher or you need a book in your hand when you're going to talk to somebody about, I know I can do this, look here.
Good, I like that. Next slide. The essence of the conservatorship is it mandates medication on that. And that's very important because it's the only treatment in California that mandates medication. AOT, CareCourt, none of these other programs mandate medication. And that is a very important thing because the brain is lacking certain chemicals that makes those neurons connect properly. So that's what this is really all about. You're going to hear a lot of things where people go, oh, you're going to lock them up for life and this and that. And even people in the hospital will say, oh, well, why do you want to lock them up? You're not locking them up. You might kind of keeping them locked up a little bit till the medications get to work and they're getting their life back and being able to think properly. All right, next slide.
Norwalk Mental Health Court. So in Norwalk Mental Health Courthouse, we have 2 courtrooms. Department A, where Judge Heron, Scott R. Heron, is the presiding judge. And then Department B, Judge Renee Gilbertson, she sits there. And both courtrooms hear conservatorship cases, the initial, the renewal, the ongoing check-ins and reporting and things like that. The courtrooms are right next door to each other. So you might want to pay special attention to what courtroom everything is assigned in for your loved one's case. There is virtual links if you're not able to make it there in person, that the court clerk here at this very same address gives access to, but these are the LPS courtrooms. And they're only in Norwalk.
The types of conservatorship, and this is LPS conservatorship that we're talking about. There's a probate conservatorship, but that's for people that are generally older, or if a person has dementia, a brain tumor, Alzheimer's, autism, whatever other problems, anything that does not pertain to serious mental illness, schizophrenia, schizoid affective, bipolar, chronic depression, those are the ones that are under LPS. The doctor in the hospital is the one that initiates the conservatorship of the person. And this is where it gives you the powers to approve or disapprove treatment, placement, and medication. If you need the conservatorship of the estate, it is not the doctor in the hospital that can request that. You can contact the public guardian. Once the doctor has initiated the LPS conservatorship, call the public guardian's office, ask who is handling the case for your loved one, get their email, phone number, and send them that history, symptoms, and gravely disabled information that we talked about yesterday. If you need it of the estate, that's if they have debts to be dealt with, school loans, court cases, anything else that they may need. It doesn't mean they're a millionaire, though they might think they are, but it doesn't mean they are. If they have real estate, cars, houses, whatever, you probably would want the conservatorship of the estate to be able to deal with these things. It is the public guardian that you can give them the information and request that they petition the court for the conservatorship of the estate for you. Or let's say you find out they have all these debts. The conservatorship's been granted. You are the conservator. You can go back to court and you can ask for this. Now, when you're in court, ask the judge to appoint you an attorney. You have a freebie attorney for the year. So should you have any questions, you can call them. And they also help you to renew the conservatorship when it's necessary. So those are important things to be able to know to do. And once the conservatorship has the paperwork from the doctor, your loved one's placed on a TCON, a temporary conservatorship, for 30 days until the court hearing is to take place, granting the conservatorship or not. Any questions you have, our public guardian in Los Angeles is extremely helpful, and they can give you when it's going to be, where, all the information you need. If you choose to be the conservator, let the public guardian know. They will interview you to make sure that you are of sound mind and you have the right intentions for your loved one. So that will make a difference for you to be appointed as the conservator. Jim, Shaylin, y'all want to add anything?
I just like to say, so if you're appointed over the person, you can sign for medication and treatment and to place them in the facility. But then if you're not assigned for the estate, which you would probably want, you can apply for their benefits. You can keep up with their insurances, VA payee, Social Security, make new applications if they get any other kind of compensation that they're entitled to. So estate is pretty important if you're going to be bill paying for them.
Okay, next slide.
So succession of conservatorship. So public guardian investigates for conservatorship, like Elle was saying, for the petition of the court. When that assigned investigator is reviewing the case and looking through court notes and medical records and things like that, when they're conducting the investigation, they may very well make the recommendation not for public guardian to act as conservator, but like with you all in your cases, for a loved one, a relative, a responsible family friend to act as conservator. Sometimes it flip-flops back and forth. If someone is not able to act as conservator, public guardian can be arranged to take over. If they're able to, if they're ready to take it back and act as conservator, if their difficulty is over with, with court consent, public guardian can transfer the conservatorship back. So it can be changed from public guardian to a responsible person at any time during the year. It's just a court approval. And it can be changed from a responsible person back to public guardian. You just would need to write a letter to the Norwalk Mental Health Court, Department A or B, to change the successor. If you are the appointed conservator and you're having difficulties continuing and you need some extra assistance, or you need public guardian to take over for some time. And the court honors the conservatee's request. The conservatee may ask at sometimes, they don't want public guardian to act as their conservator. They would rather a relative do so. The court does take that request seriously.
Yeah. Shaylon, somebody just, and I saw the little message. If the conservator passes away, what takes place right then? Would you like to address that?
Yeah, sure. So it can be another relative who is, if they're willing to act as conservator, if it's just too much of a burden at that particular time, just let the court know, whichever courtroom, Department A or B, that the case is assigned to. Just write a letter. It doesn't have to be very long or lengthy, or just that, letting them know the conservator has passed away and you'd like for public guardian to be appointed as conservator, or if you know whom else you would like to recommend, you can put their name in it, and the court will order public guardian to investigate for successor and either appoint public guardian to act as conservator or the other person that was recommended.
Okay. And usually when you write that letter, you can get this done within about a week to 10 days. It's pretty quick, and it doesn't cost you anything. But you can get it done very fast. I'm going to add a little bit of something just to kind of spice this up a little bit and keep you all awake. We had a case where the young man, the judge appointed his parents a conservator, and he said, Your Honor, this is a tall, strapping young man, and his parents were little bitty. I don't want my parents as conservators. They beat me. The judge says, all right. So he turned it over to the public guardian. And he says, we'll have a hearing in another 30 days to see if you've changed your mind. After 2 weeks, he called his mother and he said, if you're nice to me, I'll let you be my conservator. She says, I don't want to be your conservator. You're not nice to us. And before the court hearing, he says, I'll be real nice to you if you'll be my conservator. The public guardian has so many people that they deal with. They don't have the time to spend like a parent would or a loved one with them. So, and it's not that they're not trying, because believe me, they do. They tend to all their needs and whatever they need, but they're not going to be able to talk to them every day. So they get the word from other conservatees that it's a good idea to have your family member a conservator. All right, next slide.
So who should actually be the conservator? On one side, you have the public guardian's office, certainly, and then you have the family or otherwise. And how do you as a family member make that decision? So if you understand that there's pros and cons on both sides of the equation, the public guardian's office can certainly take over the conservatorship. And the plus on that, or the pro, is they'll be able to place the person in a state-approved facility. There's a lot less stress for the family member. The negative is that if the public guardian is in fact the conservator of the matter, then you'll have less involvement with the recovery process, and you have absolutely no control over what medications might be assigned to your loved one. So you want to work closely then, if it is with the conservator's office, in working with them and have a working relationship with them. You can certainly provide them information. And of course, you can assist in any sort of a way in taking your loved one places that, that they need to get to. So next slide. Then you want to consider, should I be the conservator? What would be involved? You want to remember that as a conservator, you don't have any legal responsibility in terms of costs. If there's any charges from hospitals or anything else, that's not going to come to you. But also the pro is that you have direct contact with the doctor, and you can reject inappropriate treatment facilities, medications, and treatment places. So a note on that. Let's say that the doctor is providing a medication that you just don't like, that you have other preferences that you think are better, and you deny the doctor his right to prescribe that medication to your loved one. That doctor can go to the courts and say, Your Honor, I'm the professional. I'm trained, and I'm a trained doctor, and I know what my patient needs in their treatment. And the conservator over here can't give me a valid reason as to why I cannot prescribe the medications that I want them to take. Chances are you're going to hear from the courts and you're going to be removed as the conservator. So you really have to have a very valid reason, such as we often refer to the medication Haldol. Say, I don't want you to prescribe Haldol to my son or daughter, family member, simply because they have an allergy to it that causes their tongue to swell and it cuts off their airways. That's a valid reason. So if you have valid reasons in regard to medications and so forth, that's fine. That's why you're there, that you're wanting to build a working relationship with the doctor. What are the downsides? Well, gosh, your conservatee is going to be pushing you to give them money that may be something that they shouldn't be provided. If this is my money. Oftentimes we'll hear, this is my money. You have to give me my money. No. And then they really try to manipulate you to do things that you just cannot do for them. Another negative is that when your loved one's in the hospital's going to try to push you around, and they're going to want to discharge the patient to a facility not appropriate for the level of treatment needed for recovery. Let me give you an example of that. My conservatee was in one of the hospitals here in Orange County, and I had, in booking him in for treatment, I provided my conservatorship papers, and I gave them the mental health history, the medications, all of that. And without any notice to me, they up and shipped him out to a hospital in LA County. I then contacted the hospital, and I went to their senior staff there. And I said, you're in violation of law. You cannot move my conservatee. Again, you don't want to say son or daughter. You cannot remove my conservatee from your facility and transfer them to another facility until I've had an appropriate amount of time to look at that to see if it's appropriate for my son or daughter's treatment regimens. As it was where my son was sent to, it was a known hospital. It just was not a good place to have your family member in. And so I made them stand down, and they actually moved him back out into Orange County. So again, if you want to look at negatives though, you're going to be manipulated. The hospital will try to push you around. You have to learn to stand your ground, always be polite, but don't let them push you around. Next slide.
Hold on, I'd like to add something.
Sure.
When the public guardian is a conservator, they're kind of limited a little bit as to what they do. For instance, on meds, unless it's something like Haldol that's swelling somebody's throat, that's different. But they cannot make suggestions to the doctor, where if you are the conservator, you can maybe read about some medications and you can tell the doctor, and we're going to talk about medications a little bit, but you can say, doctor, I've been reading about this medication. What do you think if we try it? The public guardian is limited on that. If your loved one wants to drive a car and they're ready for that, the public guardian isn't going to be saying, okay, we'll see that you can drive the car, or enter contracts. There's certain things that they're not going to do because they don't want that responsibility. And I understand that. Where you as a conservator can do that. So there's certain things that kind of make a difference. Now, what the public guardian can do is request a medication review. And if a doctor's got somebody on a smorgasbord of medications, be corrected. and changed. But if you are the conservator, you have more say so in these situations. Okay, Shaylin, did you want to add something?
Yeah, no, you're absolutely right. Public guardian, when we act as conservator, we're going in with the mindset that we are the absolute last resort. Nothing else has worked before. And so when we're sticklers to what the code says, and we're sticklers to, well, if they're gravely disabled, then that means that they don't need to operate or machinery or drive a vehicle because they're gravely disabled, and we need to have them in treatment to rehab them well enough where they can be in an open setting. We're very focused on their treatment and medication, and where the level of care is recommended. Most of the time, we're not so much, like Gail said, concerned about if they're able to run errands and go get a California ID and volunteer or hold a job, because those are not necessarily things that at the very end of the line is the most important to us as an agency.
Okay, next slide. Liability for the conservator. The law 5358.1 specifically says you are not liable either civilly or criminally for anything the conservatee may or may not do. You are not financially responsible for their debts or any of their bills. So if someone tries to get you to start paying their bills, remember they're over 18. That's the people we're talking about. You are not responsible for this. Now, if you are negligent and they've taken away their right to drive a car, but you give them the keys to the car and you say, could you run down to the store and go get some milk? And they have a car accident. You are liable because you did something you shouldn't do that the courts had taken away from them. If they took the keys without your permission and took off on that, then you are not liable. So you have to pay attention to what the laws are. Don't go out of the realm of what your responsibility is. And your responsibility is simple, and we will talk more about that. Only to approve or disapprove treatment, placement, and medication. And that is really important. Jim, you want to add 2 cents?
I think we've covered it so well.
Okay, Shaylin?
Let's go forward.
Okay, next slide.
So the rights and responsibility of the LPS conservator is that you have the power to approve or disapprove of all medications, treatment, and placement. Again, in regards to placements, as I mentioned prior, let's say that you're finding a board and care and the hospital says, yes, it's time to get them into a board and care. And you go to the board and care and you look across the street and there's a bar over there and your conservatee has a drinking problem. You would not want them to be in that placement. So you want to, because you're the one that's going to find the appropriate place for your loved one to live, you want them to be placed in an appropriate setting that's safe and conducive to their recovery. You have the power of the medications, but again, not to the point that you're not going to be working with the doctor. You don't want to demand a medication simply because you like it or refuse a medication because you don't like it. It has to be for a valid reason. And you can also determine the path of treatment. Are you going to have this person go to various, outpatient treatment programs? You'll be making that, whether the treatment is going to be through medications, talk therapy, or all the above, and that type of thing. So I think I've covered that. Gail, you want to chip in?
And just on the medications, when you're working with the doctors on the medication, you're looking to find the best medication that gives your loved one the greatest clarity of thinking with the least side effects. If you start saying to the doctor, okay, I want you to give them this, that doctor is going to look at you and say, you are not the doctor. I am, and I will make that determination. But what you can say is, Doctor, I've been reading about this medication. What do you think if we try a little bit of this, and I will give you the feedback as to what I see on the reactions? That would make a big difference. If you say, well, my friend's son is on this medication and it's working for him, that's not going to cut it. Because keep in mind, what works for one does not necessarily work for another. So be diplomatic when you're talking with the doctors, because when the doctors got their doctorate degree, they think they also got the God degree, and they're not quite there. Next slide.
So the conservator has the right to speak directly with the treating doctor, apply for SSI, SSDI, Medi-Cal, and so forth, any of the benefits that they should be entitled to. And of course, you can have private insurance, Medi-Cal, Medicare, all at the same time. You want to look at the best scenario, the best insurance that will fill the needs of your family member, and certainly, put all that together for them. Gail?
No, I think that's about it. Shaylin?
No, that's very accurate. Yeah, I don't have anything to add very much.
Okay.
Gail? Start.
The welfare. Okay. This is really an important law, 5358.5. As a conservator, you have the right to hospitalize your loved one when you deem it necessary. Let's say they've gone off their medication for about a week. The only place that can force medication is the hospital. So you need to get them back in the hospital. They do not need to be harm to self, harm to others. They don't need to compensate so much that now you have to spend all that time for their brain to heal. When you deem it's necessary, you can get them back in the hospital. And that's what the law calls for, 5358.5. And I need to take out Diana Hammond because she doesn't work with us anymore, but she's getting her law degree for this. But Miriam Brown, you can call. She's deputy for emergency. You can call me if you run into a problem. We want the police. The law is, and it's in that pamphlet. If you go to NAMI Urban LA, they have a guide for conservators, and the law is written out in that area. Do not wait for them to decompensate. The longer you wait, the longer they will be back in treatment, trying to get them to where they were. For instance, if you get them back in the hospital, they may go to the door of the hospital, they pop a pill, okay, you can go home. They get the message, I don't think I'm going to do this again. You wait several months, they've decompensated, they're going to have to spend time in the hospital. And if you wait too long, now you have to wait for an IMD to become available. That's at Institute for Mental Disease, and it's a lockdown treatment facility. You go from a lockdown to a lockdown. Hospitals and jails are locked down. So from those areas, they can go to the lockdown IMD. We had a hospital tell the family, take them home. We've put you on the list for the IMD. When a bed becomes available, we'll let you know. If the family had taken them home, that person could not go to the IMD because home is not a lockdown facility. You have to go from a lockdown to the lockdown of the IMD. But do not wait for them to decompensate, because your goal is to keep their recovery in a forward motion. And that is really important. That's what that conservatorship is all about, getting them back on the road to recovery, to be the person they were as close as possible prior to them getting sick. Okay, Jim?
Oh, gosh.
Where do
I'm
you
sorry,
go?
I was looking at the chat room there and I got sidetracked here. But for Orange County, just remember that you as the conservator have the right, the same right as a police officer or a mental health care worker to place your loved one into the hospital. The problem is, how do you get them there? And of course, the pathway to that would be to, as I'm sure most of you already know, would be to call OC Links. OC Links now is in charge of contacting the teams to come out and do the transport. And you can have them hospitalized based on your authority alone as the conservator. You can override the evaluation, as I understand it, but whether or not they can be kept there or not is up to the doctor and treatment team to make that determination. So, Shaylin, you can correct me on that if you'd like to.
No, you're absolutely right, Jim.
right
You're absolutely right. Just make sure you have a printed copies of those conservatorship paperwork and send it. And even if you have to set it on their lap when they're in, being transported, make sure the hospital is perfectly clear that they are a conserved patient and they have that paperwork, your letters of conservatorship on file. So they just don't automatically release them if they can't find a bed fast enough or things like that.
Yeah, and let me just say, OC Links is for Orange County.
Yes.
Call Marion Brown or call me, and we will get that under control so that they can pick up your loved one and get them in the hospital. That's really important. The law says that basically the police will transport. They're supposed to transport your loved one to a treatment facility, which would be the hospital, to force the medications. Okay?
Okay. Next slide.
Next slide. Okay, the California, okay, we pretty much covered this. The conservative court, the court has decreed that your loved one is gravely disabled. So there's really no need for an evaluation. The police have been requested to transport to a treatment facility. If they say, well, we have to call and get somebody to come and evaluate it. No, you are the conservator. You're saying where you want them to go, and they are to transport. The court has said they're gravely disabled, and nobody can go in and say, well, no, they're not, because that's contempt of court. If they want to change that, they have to go to court and have that gravely disabled taken off. So, and we talked about the hospital's the only place where you can mandate medication. And you are the author of this. You have the authority to detain and treat. Shaylin, you want to add 2 cents?
Yes.
Oh,
yes, next slide, the ADT. Yeah, so next slide, please, Araceli. So the ADT, so on top of making sure whatever facility or hospital or lock placement has a copy of the letters of conservatorship and the orders that go along with that, you also want to make sure that you as conservators sign this form or you send over this form. It's an authorization to detain and treat. So the detain part is for them to hold them, your loved one at that facility if they are needing to be in a lock placement or hospitalized, and to treat them, right? To kind of bring them back down to baseline with medication, talk therapy, redirection, whatever it would take. Usually it's a combination of all those things to stabilize them, to bring them back down to their baseline, to their back to themselves, if you will, whether that take 3 or 4 days or it take a week. And in some cases, it may take a little longer. But when you submit this paperwork, this signed ADT or authorization to detain and treat, the hospital has to hold them to either the treating psychiatrist at that facility is making orders saying that they are ready to discharge, or, usually that's a discussion with the conservator so that they have enough time to prepare and see where the next either placement or if they're ready to come home in your cases or not. But this form and document is very important to hold your loved one there at the facility or hospital so that anyone can't just release them at any time.
Right. Okay. And if I'd like to just add one more thing, if you're looking at having to do this, what you could do is go to your local police department, to the watch commander, give them 3 things. 1, a copy of your conservatorship, this and then this detain and treat paper, and write a statement. You, as conservator, deems it's necessary to transport your loved one to the hospital. Now, the one thing that helps on this, if you find out from the hospital, whatever hospital you want them to go to or where you want them to go, if there is a bed available, the police are more inclined to be respectful and help you with this. So if you can talk to their treating doctor, have the treating doctor locate a bed for you, and you let the police know they can take them to this hospital, that's most helpful. So you give them a copy of the law, a copy of your statement that you deem it's necessary, and copy of your conservatorship, and also this detain and treat paper. It really helps. Give that to the watch commander, get a bed, try and see if you can find a bed available. It'll make all the difference in the world. Makes life a little bit easier for you. Okay, next slide.
CalAble is a government organization that is really designed for you to be able to accrue your funds for your loved one. Basically, I'm sorry, I have to clear my screen. This page lists the different disability-related expenses that can be paid for without losing government funding. So if you were to go to calable.ca.gov and look at the expenses, it allows you to purchase things that would normally not be allowed for the money to be spent on. And so I think, as I recall, Gail, don't we have an upcoming list of some of those expenses that will...
Think a little bit. I think we do.
Yeah, because if you were to buy things that for your loved one that they should not be receiving, that's one thing. But CalAble then allows you to kind of get around some of that. So let's go to the next slide if we can.
This is good if the person is under SSI, because if you, let's say they're going to a board and care, and the board and care is $1,200, and they get like SSI will increase it to $1,200. But let's say you choose another board and care that's a little bit nicer, that might be $1,400, and you say, okay, I'll pay the $200 difference. SSI will decrease their income by $100. It's every $2 to $1, something like that. So to keep that from happening, if you go and you sign up for CalAble, you can do that. You can put your money into CalAble and then write a check to that board and care, and it will not affect their SSI. Now, if they are on SSDI, you don't have to worry about it. But if they're on SSDI and they add a little bit of SSI to bring their income up to a certain amount, you better darn well think about that, because they get very anal about you spending your money on your loved one. Okay?
Right.
Shaylin, did you want to add anything on that?
No, everything's covered. Yeah.
Okay. Jim?
No, that's what you said is actually an example that I once utilized myself. But you can spend the money if you go through CalAble on housing, transportation, you know, anything that's needed for their well-being and wellness. You can buy them a computer. You can buy them anything that is going to help them in their daily life, as long as it is going to come through the CalAble funds. So some of these things that are on this list, if you were to spend the money on, it's, as I understand it, not really, especially for personal support, is not going to be approved by Social Security. But these things are, if it's through CalAble. Next slide. Yeah.
LPS Conservatorship of the estate allows you to negotiate debts. If they owe a telephone bill or a credit card or something like that, if they have any money to work with, you can contact the creditor or the credit card company or whatever, and you can tell them, look, I have X amount of money that I can pay you, and you can do 10 cents on the dollar, 25 cents on the dollar, whatever. I will pay you this, but I want you to write that this has been paid in full. So you don't come back later on and say, okay, we want more money. You can negotiate for them. If the creditors refuse to negotiate with you, don't worry about it, because what it'll go on maybe on their credit report as a judgment. But after 3 years, that is taken off. So you don't have to worry about it. You can handle criminal court cases. You can acquire a waiver for their school loans. And let me tell you, that's a big one, because their school loans, if they're not being paid, they don't go up like, oh, $1,000 a year or something like that. I mean, they will jump from 3,000 to 6,000 and then 9,000, and you're going, holy mackerel, how are they ever supposed to pay that off? You can get a waiver for their school loans, and after 3 years, if they're still in poverty, the school loan's totally dismissed. You can cancel credit cards, which I don't know about y'all, but I sure like that one. You can ask the court, be sure when you get that conservatorship, or even if you have to go back during the year, ask the court to appoint you an attorney so you can ask questions should you need any questions answered during the year. It gives you access to a legal attorney. And let me tell you, you may not think you're going to need an attorney, but many times you do. Something comes up and you go, oh, what do I do now? And those attorneys, they're free and they're very knowledgeable of your loved one, of their situation. It might be a question on Social Security, on SSI or SSDI, or somebody's giving you trouble about something. That attorney is your attorney for your benefit to help your loved one. Okay, Jim, Shaylin?
No, I think you got it down.
Yeah, everything. Yeah, they cover.
Okay, next slide.
So
Shaylin, go ahead.
Yeah, no, it's okay. Conservator must have court approval for all invasive medical treatment. So when you become conservator under LPS, you are given psych treatment and medication consenting powers, but not for medical, unless it's a pre-existing condition that you've already informed the court about. So invasive medical treatment is anything that punctures the skin, right? So you would not think that a flu shot is invasive, but according to the court, it is. So the court needs to be petitioned, and you need court consent if there's a major surgery, or if there is a x-ray with dye contrast insert, things like that, for anything that's going on medically, because you are conservator, but over mental health, not medical. So you would need to inform the court if you already have a standing knowledge of all medical issues and problems and diagnoses. So you will have kind of a pre-consent that kind of cover and blankets everything. And that is under Power 12 under your letters. But if not, you'll have to go into the court, or make contact with your attorney, utilize your attorney to petition the court to get consenting powers for whatever procedure or surgery or invasive medical treatment is upcoming or needed.
I will add that there was a conservator here in Orange County that somehow missed this information. She was conservator of her mother, and the mother needed a very serious operation on her stomach, and she approved of it, not knowing that she had to first contact the courts, and I believe she lost her conservatorship. So you want to be very careful about doing things such as setting up appointments. Shaylin, what about the dentist? Because you said even if they have a needle, a shot, Are you going to go
Yeah,
to the
so the
court to
numbing
fight?
is also considered invasive procedure. Yeah, because of the numbing and things like that. And even when or if the procedure is given court consent, you may not necessarily be able to get your loved one to still give their consent, even though they lack capacity, right? Because if you take them to the dentist and put them in the chair, you have all these papers saying, yes, you can go ahead and proceed, but they very well may not open their mouth.
Yeah.
So you just kind of want to speak with them and make them feel like they're involved in this decision and, counsel them of the benefits and also the risks, right? You don't get this bad tooth taken out or pulled. It can get infected and get in your bloodstream and make you very ill, things like that. But yeah, dental treatment beyond cleaning is considered invasive medical treatment. And you would need to get the court consent for that.
Shaylin, if they don't open their mouth, isn't that what a crowbar is for?
Oh my goodness.
Hey, I gotta
Yeah.
keep the light around.
So yeah, I know. So what we usually do in those instances is we keep talking to them and retrying and making future dated appointments and things. And maybe, because it's private conservatorship and they know that you love them and want what's best for them and you have a personal relationship, they may be more prone to do what you're suggesting more readily.
Oh, but I do want to add that if it is an emergency, would you like to address that, Shaylin?
Yes, very much so. So I think it's also the next slide, please, Araceli. But yeah, so invasive treatment, right? So that's anything. If it's a medical emergency, all non-emergency invasive procedures must be approved by the court in Department A and B. But if it is emergent, then even though as conservator, you cannot give consent, you are going to notify the doctor or whomever is asking at the medical facility or hospital and letting them know that U.S. conservator cannot give consent for medical, but if it's an emergency as far as like life-saving procedure or it's emergent, at risk, they're very much at risk, that the facility or hospital should follow their internal procedures on an emergent basis. So that's usually one doctor having a witness of another doctor, two doctors in agreement, signing off on the medical chart. And then they would just notify you as conservator what their plan is, why it's emergent, and kind of keeping you with updates. But you're going to very much ask them to document that in the chart, that it's done on an emergency basis. Also with medical consents, there's no experimental treatments that are permitted by someone who is under conservatorship, and then request for all medical issues to be approved by Department A or B. If you feel like it's something they could benefit for and it's something newer, you can ask the court for the consent.
Okay. Would you like to address the what is it?
Electroshock therapy. Yeah, so the court is not a big fan of that. I feel like it's a bit archaic and they really pine over it. They really spend a lot of time trying to make a decision when a treating psychiatrist has made this recommendation. They really want to know and see that the treating doctor and the treatment team has tried everything else and nothing else is working, and the patient, your loved one, is just not responsive. I've only had one patient that we were successful in getting the consent for, and he was catatonic for several months, and they had tried different medication regimens, different dosages, and he was not responsive at all. So we proceeded with the court consent for they only approved for 3 rounds of electric shock. The doctor wanted 8 to 10, but they only approved for 3 and then told them to come back and see after those 3. But that was a more extreme case and things like that.
And I'd like to add, if you're dealing with the VA, be cautious because they tend to want to do the electric shock. Okay. Next slide. The conservator, you have as conservator direct contact with the treating doctor, but be respectful. They're very busy. If you can go through the social worker, fine, his social worker or whatever, fine. But if you have to talk with the doctor, write your notes down first so you're not rambling. They don't want to know about the weather and what was taking place during this and that and his whole life history when he was born or any of that stuff. Unless they ask, but keep your questions very much to the point. Ask your questions and then, let it go with that. The California Welfare and Institutions Code 5328.1 gives you the right for your prognosis, medications, side effects of medications, and to have direct contact with that treating doctor. If the doctor refuses to speak with you, Shaylin, is Amanda Ruiz still working? She left, didn't she?
Right, she did, and they have what I found out last week, they have not found a replacement for Dr. Ruiz, but this 213738 number is still a good contact number for getting some assistance with that.
Okay, sounds good. And I'm going to just add a little bit something on Amanda Ruiz. She is working with a group now in Antelope Valley where they are putting together a state-of-the-art program, which will have an IMD, basically a step down. Their treatment facilities will include exercise gyms, places where they can do activities, dancing, you name it. I mean, they've listened to NAMI members. This is where your voices are so important to say, what is it that you feel will make a difference for our loved one? But this is down in Antelope Valley, which is kind of a little bit far away. But this should be opening in about probably 18 months, but they are working hard on that. And she is very involved in that. Okay, next slide. Oh, I'm sorry, Jim. Did you want to add something? Okay.
No, I don't.
Okay. Next slide. In criminal court cases, ask the public defender, when your loved one has a criminal court case, ask the public defender to request the Department of Mental Health court linkage program, and that's the phone number for them to be involved in the case. Consider the linkage program, to be the key to unlock the doors for different treatment programs. You can request for a jail or a misdemeanor diversion program. Basically, these programs are usually good for about 2 years, 18 months to 2 years. And often at the end of that time, if your loved one is successful, the case can be dismissed as if it had never happened. So that's pretty good. Now, the one thing when your loved one's involved in a court, remember your rights are to approve or disapprove treatment, placement, and medication. When criminal court is involved, your right for placement is second to the court. The court states where they're going to go for placement for their treatment. So you're second to that. But that court linkage program is very powerful. They're very helpful. And you don't need to pay for an attorney. The public defenders know all about this. They've been highly educated on these programs. And this is where your conservatorship of the estate comes into place, where you can really deal with the criminal court cases. Shaylin, you want to add 2 cents?
Yeah, so we're seeing now more than ever a lot of forensic is what the jail or prior charges, forensic conservatees. They're conservatees that have a forensic background, especially coming into the public guardian's office. So the population is changing, right? At some point or another, we're finding a higher population of conservatees that have some kind of arrest or history of or pending charges or just things that need to be resolved in criminal court. Conservatorship is a great plus to that because it helps the judge in the criminal court kind of know and understand what's going on mentally with the with the loved one. But like Gail said, it is conservatorship is secondary to the criminal court in case proceedings. They take priority. They have the first jurisdiction.
Mm-hmm. And I'd like to add, when you're dealing with a criminal court case, that history, symptoms, and gravely disabled that you put together, that paperwork, when you go to court, give that to the public defender. It helps them on working with everybody to get the whole process in place. That's vital. Now, what's good about if you're getting a jail diversion program and you have an LPS conservatorship, remember the essence of the LPS is medication. That is your insurance policy that this person most likely will be able to finish their program. Because if they go off their medication, even for a week, you as conservator can get them back in the hospital, get them back on their medication. If they're not under the LPS conservatorship, they can go off that medication for a long time, maybe go back to drugs, and it'll be a while before they are able to get them back in the program, if they even accept them back in the program. So that LPS is a great insurance policy. Count your blessings. Jim?
No.
Okay. Next slide. This is mine. These are possible treatment programs. The LPS is the one that has the mandated medication. That's the cream of the crop, you might say, but not for everybody. Sometimes other programs are more appropriate. Assisted outpatient treatment. You cannot be under the LPS and under AOT at the same time. It's one or the other. But they're well in Los Angeles anyway. The people in the assisted outpatient treatment are well trained in how to work with your loved one. Care Court is another one, and they're very similar to AOT. They're just certain things that they request. Care Court tends to request predominantly schizophrenic or schizoid affective or something with that schizophrenia spectrum. Home team, if your loved one's homeless on the street, they're very good about going and finding them. They don't want to be looking all over. They're not going to be able to find that needle in the haystack. But if you can help them find your loved one, that makes a difference. And the full service partnership program. These are programs that offer your loved one whatever they need for their recovery. And so we're blessed in Los Angeles. Working with a person with serious mental illness is extremely difficult, especially if their brains are not in touch with reality, because you have to be able to communicate with them, establish rapport, and try to convince them to do certain things. And that's a tough way. I mean, you as parents or loved ones working with somebody, you already know how tough it is. And the patient tends to think you have the problem. They don't, which makes it really difficult. But these are programs that they are highly educated and pretty good at doing what they need to do. They're not perfect, but they do their best. Okay. Anybody want to add 2 cents? Okay, next slide. Jim?
Medications. You need to know all your medications, the side effects, the dosages, when they're to be taken, whether it's morning, night, or both, and do research on those medications. Drugs.com is both an app and a website. Pretty much just about every medication you can think of is actually listed in this app or website, and it's doctor peer review the doctors basically look at the drugs that are to be posted onto that website, and they put everything in there that you'd ever want to know, such as what is intimating above, side effects, dosages, recommended dosage ranges, and all the rest. The National Institute for Drug Abuse, which is the NIDA, basically, I'm not sure where that one's going, but medication that works for one does not necessarily work for another. And I guess that's something that I guess they had posted, but not all medications will work the same for everybody. And that's where you need to rely on your doctor. You need to take notes on the medications and how they're working and so forth, and stay in close communication with your doctor. You want to write in your journal the date of the medication. And excuse me, I need to close off this chat so I can read this. Write in your journal the date of the medications and their behaviors. So yes, you want to absolutely look at, especially, the medications that have just been introduced. Is this having the kind of desired effects that it should have? If not, you want to let your doctor know that. What I see is that as time evolves, not all of us are always able to stay with the exact same doctors, in and out of hospitals, and things change, and you end up having to seek out a new psychiatrist. This journal then becomes a gold mine for you, because the doctor might ask you about different medications, what has been effective or not effective, and this journal that you're keeping on the drugs is so vital to have on hand. So again, write in your journal the date of the medications and the behaviors, whether you're working well, not working well. The goal is to find the best medication for clarity of mind with the least amount of side effects. Gail?
Okay, and yeah, I would like to add, first of all, I tend to be an East Coast person, so I am not PC, and I speak my mind. In my opinion, and please understand, I'm not a doctor, lawyer, psychologist, any other such thing. But Jim and I have been dealing with this for like 25 years or maybe longer. I don't know. But when people call and ask me questions, one of my questions when they're telling me their problems, what medication is your loved one on? And I would say the doctors tend to write prescriptions for medications that are good for a person that has a mental health problem. Your loved one has a serious mental illness. It would be like if you have a migraine and I have a headache and I say, hey, take my Tylenol, it'll help your migraine. It won't phase your migraine. It's the same with these medications, and this is my experience and my opinion. Medications such as Zyprexa, which tends to blow you up like a balloon. Abilify is may work and may not. Chances are it won't. It works beautifully for a person who has a mental health problem, but not a serious mental illness. Zyprexa, Depakote, Ativan, those work for people who have a mental health problem. You most likely will have to up the ante for your loved one who has that serious mental illness. The medications that I find tend to work, one is Invega, Invega, and it does come in a shot form. And what all the pharmaceutical companies will tell you, they recommend the shots every 4 weeks, but each person metabolizes differently. So if 3.5 weeks, your loved one's saying, I'm not going to take that shot, and their personalities change, they metabolize rather rapidly. So they should be given it sooner, not every 4 weeks, but maybe 3.5 or 3 and 5 days or something like that. Likewise, some people metabolize slower. So if 4 weeks come and they're doing great, push it to 4 weeks 1 day, 4 weeks 2 days, till you find out where they are. The Invega is the same chemical composition as risperidol. The difference between the two drugs, risperidol is an older one. Risperidol goes to the organelles in the cell. So you get a variety of messages to your to do, and you get a lot of different side effects. Generally, you tend to be more tired, not so motivated, whatever. Invega tends to go to the nucleus of the cell, so you tend to be more alert, more motivated, less tired. You might take a nap in the afternoon, but you're less tired. If it works for you, keep in mind what medication works for one does not necessarily work for another. Another one is Vraylar, V as in Victor, Raylar. Now, Vraylar and Cobenfine are the only two that I am aware of that work for people who have negative schizophrenia. And by negative, it's things that is taken from them, their personalities, their laughter, their charm. They're like the walking zombie. And they really are when you see a person with that. Positive schizophrenia, which is all the other drugs are made for, is things that are added to them. Their delusions, their visuals, their verbals, all that, that's positive. But, when you're dealing with somebody, all these medications, you're going to work with the doctor on it. But if you have a better idea, you'll be able to work better with that doctor. I have had many people call me, and when I ask them what medications they're on, they give me a smorgasbord of Depakote, Zyprexa, Ativan, Seroquel, and whatever else. I can tell you right now that they're all over the place, and they are. And so I go over, just guidelines, try to find one medication that works the best for them at what level. Then if you have to add another one, you do. But if you've got 4 psychotropics, you want to tell me which one's working? Because you would have no idea. Others that are pretty good is Cobenfine. Now, on the East Coast, I've heard several doctors say they really like it. I've not had anybody in California do Cobenfine. You can also contact your pharmaceutical company. They'll tell you everything you want to know. If your loved one's on other medications, call the pharmaceutical company, tell them what they're on. They'll tell you whether this is good or not. Let's see. Latuda, Latuda, that is another one that's good. And clozapine, that's kind of what they call the gold standard. I don't tend to think it is because I think too many people have been on it and it hasn't worked. But if it does, it is very good. That's the one that they do the blood draws because the white blood count can get off. And it's a precaution. Only one person out of 100 has a problem with that. So if it works for them, it's good. But I would not do it unless they're under the LPS and in the hospital. Because if they go out of the hospital and they're going to tend to stop taking that shot, you're up against them. You don't want that to happen. Keep in mind, try to find one medication. And when you're working with that doctor, remember, be very diplomatic because they think that they are the answer to everything. And unfortunately, a lot of doctors don't work to find the best medication for your loved one. And I'm really going out on a limb now. They find the best medication that's going to give them the best Caribbean cruise. Next slide.
Oh, Acerelli had a question for you guys.
Oh, okay, sure.
What was it, Acerelli? You wanted the 2 medications that she was talking about? Well, I guess
the question was, what are the 2 medications that you mentioned that were best for schizophrenia at the beginning?
Oh, Invega, I would say 85% of the people that I talk with that use Invega, Invega, they have pretty darn good success with that. But tardive dyskinesia can be a problem. And when they go on the shot, weight gain can be on the shot. But they're more motivated, so they'll tend to go to a gym and work it off if they can. Invega is the same chemical composition, same company that makes it, as Risperidol. That's Resper. I think IDAL or something like that. It'll be on drugs.com, which Jim told me about drugs.com, which is a great resource. Vraylar, V is in Victor, Raylar is a very good one. And that works very well for both positive and negative schizophrenia. And Copenfy, which is now a new generation, it's made out of New York. C-O-B-E, Copenfy, C-O, or my spelling's not so good, P-E-N or B-E-N-I-F-Y. And that is good for negative schizophrenia. And that, I haven't had any California doctors say anything about that. I don't know of anybody being on it in California, but in Florida, yes. And they like it a lot. So, I mean, if that helps.
I'd also recommend that you cross-reference to see what insurance your loved one has and what's covered and for how long, right?
Oh.
Because you don't want them to start on a wonderful medication that seemingly works for them, and then it doesn't extend past 3 months or 6 months, or you start having difficulties getting it filled or getting the IM, which is the shot for it, or things like that. So
Right.
I would definitely recommend checking to your insurance, calling your insurance company and seeing what medications they cover, and see, cross-referencing and seeing what is closest related to that medication if happenstance that it's not something that's covered.
Right. Well, you can get that covered pretty easily. All your doctor has to do is write the formulary, which is really one page. We've tried this, this, and this, and we're trying that. The other thing you can do is you can get free samples. You can call the pharmaceutical company, give them your doctor's name and number, and they will tend to deliver free samples to the doctor. So you can try it and see if it's going to work. And if it is, the doctor can write the formulary, and almost all your insurance companies will add that. And I saw down in the bottom, somebody I didn't mention, Caplita, that's also one that works really well. Now, when you see these advertised on TV, they always advertise them for bipolar, but they are for schizophrenia too. And the reason they don't advertise them for schizophrenia is because people freak. I mean, if I'm visiting my friends and I go, oh yeah, I've got to take such and such medication, and they go, oh, that's for schizophrenia. We didn't know you were nuts, So they just basically keep it. They advertise on TV for bipolar, but these, if you look them up, they're all for a variety of illnesses. Okay, but that formulary is easy to get. It's not that difficult. You most likely can get free samples, so you can try it. Then if it works, that's even more reason for having that formulary. But you want to seek the medication that helps your loved one the best. And the other thing is, when these doctors say, well, that's the best you're going to get, don't settle for just okay. Go to that photo album, remember what your loved one was like, and that's where you're seeking, is to get them back to their old self as much as you possibly can. I think when I first started doing this, Invega had come out and it was pretty good. And this one girl, the doctor had her on a medication, and the mother said, well, could we try this Invega? Would that be all right? It doesn't matter. All medications are the same. I think I get another doctor. And she did eventually. He finally tried it. That girl was able to get a job, work for like 15, 20 years, and got her life back. That's how much that change was for her. And she was extremely ill. I mean, her delusions were that Hitler was coming after her and he would show his teeth and I'm going to do this to you. I mean, she was living in hell and scared to death. So when they changed the medication, it was a day and night for this girl, so much that she got her life back. So seek to help them to get their lives back. You are their greatest resource for recovery, and keep it in your journal. This is very important. Okay, I can be quiet now.
I don't know. I doubt it.
I'll try.
Okay, I love to tease
Oh
you.
my goodness.
Okay, let's go ahead. I'm in trouble now.
Next slide, please, Araceli.
Yes.
So
So,
placing conservatee in the treatment facility. Now go ahead, Jim.
no. Why don't you take this?
Okay, ICD, Intensive Care Division of the Department of Mental Health, evaluates and suggests where a person should be placed. This is after the treating psychiatrist makes the recommended level of care, right? So the doctor kind of decides after evaluation, and then the ICD team then comes in and assists with placement and kind of navigating everything and helping your loved one getting to the correct level facility. But you, as conservator, you're going to want to tour every facility and ask as many questions as you have curiosities about, right? Because you're going to be leaving your loved one there. So you're going to want to make sure that every aspect of their life that you're most concerned with is, covered in the best possible, placement for them. And then as conservator by law, your request for placement facility should be honored. And as like I just said, as best as possible. You want to make sure the facility's clean, that the staff are well trained, they act like they really want to be there, that they have a heart to serve, that that's something that they want to do and where they want to be, and that was their preference. Just write on every contract and admission agreement, your express written permission must be given for any change in medication, treatment, and placement. So that they can't discharge without your consent. They can't change the medication unless you sign off on it. And they can't do treatments and talk therapy and other kind of things that you haven't previously discussed with staff that you haven't really met.
I think you just really nailed it. But I would like to add, I always tell everyone that you should go out and buy the Pentel Energel pens because they have this remarkable fine little tip on it, and you get it down to a 0.03 on this thing. Where it says, to write on the contract, your express written permission, and down at the bottom, you can read the rest. You need to take a pen with you, and that has, the ability to put fine print in between the lines. Many times I've had to put my conservatee into the hospital, and I pull my pen out and I start writing, and they go, "What are you doing?" And I'm exercising my legal rights. I'm just simply writing in here that my permission must be granted. It's so important that you have a pen that will allow you to write in between the words of these contracts that the hospital slides across to you. Just a little tip. But
okay. And I would, yeah, Jim, I'm sorry, I didn't mean to interrupt.
No, done.
I would also like to add that when you go to visit these facilities, that you have questions, have it on a piece of paper so that you can ask, you won't forget your questions, and be sure to include the one on sex. You don't want the lecture on the birds and bees. You want to know what their idea is on sex, because you don't want your loved one to come out and now you're going to become a grandma or grandpa or something like that. So be sure, what is their policy on that. They can't prevent people from doing things, but they can kind of curtail or maybe help out a little bit so that things don't happen that you don't want to have happen. Okay. I tried to be quiet, but I couldn't. I tried.
Love it. Okay. Why don't you go ahead?
Oh,
Jump in.
it's the hospital. When they're in the hospital, you've gotten your LPS, that they request the intensive care division to evaluate your loved one. They come and they evaluate them. They look at the paperwork that the doctors said, and you can contact ICD. You have to give them a copy of your conservatorship papers because they won't talk to you unless you have it. By the way, if you go to court, take cash to get your conservatorship papers at that time if possible. And you really only need one. You can make copies for everybody. But you do need that paper. That when they they evaluate them, they generally give you a list of 3 facilities that they suggest for your loved one. You can go out and look at every one of those facilities and take your questions and ask all the questions, therapy, programs. What do they do? How do they handle if your loved one AWOLs? What do they do? You want all these things answered. But if you go out and you look at these facilities and you go, this isn't going to work, you can call ICD and say, look, this one facility isn't going to work because my loved one's very bright. They're catatonic schizophrenic right now. And this is very low functioning. I think it's going to freak them out. Or maybe another one where they're packed in like sardines and he's like, you're in my space. Why are you in my space? And you're like 6 feet away. Or another one, they're selling drugs across the street and it's this person has, co-occurring substance abuse. That's not going to work. You can ask them for another facility. But if you go in and go, well, it really needs to be painted again, it's not really pretty, forget that. They're going to ignore you and they can remove you as a conservator. So you want to work with people. And if you do object to a place, have a pretty good reason as to why you do. Remember, we talked about they're transferred from a lockdown to a lockdown facility. Your IMD is a lockdown temporarily. What happens when they go to the IMD? It's a lockdown. As the medication starts to help their brain and their brain is healing, they can give you time to take your loved one out, like for lunch or maybe shopping or something like that. There was one IMD that let us take our son out for 4 hours. Well, after 2 hours, it was returned to sender. Y'all can have them, But within 3 months, it was like taking them home for 3 nights out of the week. So they said, we really need to discharge him. And we hated to take him back because he was so much himself the way he was prior to getting ill. So it's not a lockdown for life. And you'll hear people go, well, why do you want an LPS? You just want to lock them up for the rest of their lives. No, you want them to get well. Now, let me just say, while they're in that hospital waiting for an IMD, that's the time and the place to work to find the best medication that's going to help your loved one. And that is so important. As your loved one is being helped and they're not a flight risk, chances are if their thinking and their reality and their abilities are coming back, they might be able to skip an IMD and go down to enhanced residential housing. There's a variety, and they could even go further. It depends on the individual. But while they are in that hospital, work with the doctor to find the best medication that can help them. Okay, I can be quiet. Jim?
No, I think I'm good.
Shayla?
As always, you nail it.
No?
Yeah, no, that's everything. That's the most important. Yeah.
Okay, next slide. Treatment and placement via the jail. Generally, a person in the jail will be sent to a state hospital, which is Patton or Metropolitan. Those are the ones they tend to use in Los Angeles. There are other state hospitals throughout the state, but they do try to keep your loved one near where the families are as best they can. You remember, if they're coming via the criminal court or forensics situation, you have lost the right for approving or disapproving for that. So no comment?
This particular placement at the state hospitals are usually, like Gail said, from jails or from prison. And it's usually a lot of the population is where incompetent to stand trial, or they're in competency training and everything at the state hospital. So they have a rigorous mental health treatment program there, both at Metro and at Patton, to kind of rehab them to see if they're ready for trial, or while the criminal courts are going to decide to dismiss or what exactly they're going to do on their end. but it's ideal for your loved one to be stepped down to an IMD facility as soon as possible from a family standpoint. There's just more services for whole person treatment at the IMD.
Okay, next slide. Jalen?
Gail, can I excuse for a minute? I have a very important urgent call coming in.
Sure.
Thank you.
Okay. Jalen?
So normal movement through treatment facilities. Usually conservatees begin at the highest level of care, acute settings, right? So hospitals, state hospitals, locked facilities. And then from there, they are stepped down to an IMD, Institute for Mental Disease. And those facilities are all blocked placement. The treatment program at IMDs used to be a 6 to 9 month program, but in recent years, we found that that has kind of been extended to maybe 9 to 12 months. But it's really hard to say because each person is an individual and treatment is not linear, right? So someone may be able to be at an IMD and do really well and complete the program in 6 or 7 months. And some others may take a little longer to acclimate to the program and to speak with their social workers and be involved in their treatment and take a little longer. But that is a really critical stage of treatment because that prepares them for back to community placement with a better understanding of their diagnosis and, understanding their medication and what options and what things they can do. From the IMD, it's an enhanced residential settings, the ERS. It's a secure facility. It's like a halfway step between an IMD and an open setting community placement at a boarding care. It's just like a little half step where it's secure. There may be more locked doors, but it's not ever like they are not ever in the community like with the IMD. There's services that are there. There may be some services that are off the campus, but it's kind of preparing them to push them along to be in an open setting at the boarding care. The boarding care setting is the least restrictive setting. All these level of care placements are licensed facilities. And at the boarding care, services are still provided, but they may be off-site. They may have an FSP program that provide outpatient mental health services. A conservatee that lives at a boarding care could very well, if they're privately concerned, could very well go volunteer or go visit their family or, have a volunteer kind of job and then go back to the boarding care in the late afternoon and evenings. They must go from a locked facility, hospital, or jail to a lower level, right? Because they're stepping down. And like Gail mentioned earlier, the conservatee may be doing very well in treatment and skip a step and not necessarily have to be at an IMD to an ERS to a boarding care. They may go from the state hospital because they've been doing well there so long to an ERS or things like that. And as long as they're not a flight risk, this plan usually works really well.
Right.
Go ahead, Gail,
and
I'm sorry.
I add that as parents, when you go, or a family member, when you go to an IMD or some of these facilities, especially an IMD, a lot of times when you go in and you're touring it, a lot of people will say, I don't know about that. My loved one is not like these people. Keep in mind that when these patients come to the IMD, they're sick. They're really sick. If you watch 2 months down the road, you're going to go, that's the same person that I saw back then. I mean, they really change a lot for their recovery. And I'll give you an example. When one young man went to an IMD and they had 2 desks, one for each kid. And the other kid said, and he had cards all over. He's one of those card people. And he says, you touch my cards, I'll break your legs. Well, in 2 months, that other person that went there was going out on where he could go out and he could take somebody out out on an outing, be like the supportive person for that. And the one with the cards, that was the only one he would go with. He really had respect for him. But you see the people change, and it's the most remarkable thing you'll see when they go from being so strange to becoming so normal. And it is, I'll tell you, it's refreshing and it is a blessing to see the recovery for many of these people. So, I mean, keep in mind when you go there, don't freak out about what you're looking at. Just keep in mind they're sick and give them time. You're going to see an entirely different person. And Shaylin, I'm sure you've seen that many, many times.
Yeah, the buddy pass system really works.
It
They
does.
become the best of friends.
It,
Yes. And then also there's so few IMD facilities in Southern California. So while you do have some choices, there it's very limited. There's only a handful of facilities at this level. And
mm-hmm.
the beds are so hard. The waiting list to get into these beds are just long, long months and months and months long.
Mm-hmm. If I can make a suggestion, if you all really want to get involved, call your board of supervisors, write to them and tell them we want the county to start building and sponsoring IMDs and paying for them. They should. They've known about this problem for 20 some years, and they really haven't done a whole lot to alleviate this problem. So call your board of supervisors, be adamant about it, write a general letter and get all your friends and neighbors to sign it and send it to them. We need board and care so people are not lingering in a hospital for 6, 8 months. That's ridiculous. Okay, that's your advocacy. Next slide. Shaylin?
Yeah, so the doctor can request the court remove you as conservator. And I mean, you must be reasonable, but the biggest thing or the biggest way that they kind of do this, one is because they sometimes don't like the way that you don't see things the same way they do, and they're just used to saying it and it being that way. They can write a letter or contact a court to request your removal, but they mostly say when they do that is the signed conservator is not in agreement and is being not in agreement with the treatment plans and refuses to sign consents for medication or treatment progression and things like that, that beyond you not being in agreement with it, they're kind of saying that you're refusing and that they're not able to contact you or have a normal conversation with you about moving treatment along. And the court can, hear both sides, but there is the opportunity for the doctor to explain to the court several reasons why and have you removed as conservator. You have the option to, if you kind of feel that coming along, you have the option to change the treating doctor. So just because that's the assigned doctor does not mean that that is the doctor that you must stay with for your loved one. You're the conservator. You're supposed to be putting together a team for whole person wellness, and that is going to work with you as a team for the betterment of your loved one.
Mm-hmm. You covered it. Next slide. Conservatee's loss of rights. Temporarily restriction for the conservatee would be the right to drive a car, enter contracts, and to determine where they live. Those can be reinstated. Now, if the public guardian is the conservator, they're going to tend not to allow that. But if you have a private conservator, your parents, your relatives, whatever, they can do that. More permanent restrictions is the right to shoot and possess a gun. And I believe, correct me on this, Shayla, I believe that's also a federal thing for 5 years, if I'm correct.
Yes. Yes, I mean, there are ways to remove it sooner than that, but it involves a court order. But most of the
Right.
time, it usually takes that about amount of time for them to find their footing off of conservatorship. So it
Mm-hmm.
waits.
Okay.
Yeah.
All right. Next slide. Reinstate the rights of the conservatee. If you want your loved one to start driving a car and you feel they're ready for it, you write a letter, just one page, doctors don't want to read, that you feel that your conservatee should be able to drive. The doctor fills out a form. It's not a big deal. It's on that booklet that you get when you're a conservator, and submits it to the court, and the court approves the right to drive for the individual. The Department of Motor Vehicles will evaluate your person and approve their right for driving. And it's a safety place. They have some place that they do this with. And it's really not a big deal. It's, give us your name, rank, and serial number. Yeah, you seem to be okay. And they let the person drive. They reinstate their driver's license. The right to enter contracts, you can request the doctor reinstate, or that not the doctor, but the court reinstate their right to enter contracts. And they may need that if they're doing something like selling something or in a job that requires that they sign contracts. Or in one case, we had a fellow get married. And so he needed to be able to sign a contract, but he was getting married, and they gave that right back to him while he was under the conservatorship. So, and that helps. By the way, in that particular case, his wife became his conservator. I loved it. It worked out beautifully. Okay, next slide. Or Shayla, did you want to add anything?
No, you mentioned it. I was like, most of the time it's involving marriage.
Oh,
That's usually the
really?
biggest one. Yeah.
Okay. Jim?
No, I find that very interesting that it usually involves marriage.
I
Never
did
heard that
too.
before.
I only knew the one case, but
It's
that
new to
was
me.
good.
Yeah.
Okay, next slide.
So renewal of conservatorship. Starting the renewal process 3 months early, there will be the physician's declaration that needs to be completed, having the 2 doctors sign, stating that the loved one is still gravely disabled. You want to make sure that you get that form that's sent over from the court over to the doctor early so that they can process it and get it back to you in time.
Okay, I have a question. A lot of times a patient is under one doctor. Can you address the 2 doctor situation?
Right. So you want the treating psychiatrist to have this document and form first so that they can do a current evaluation, not what they saw last month or 3 months ago, but current, and evaluate. It's just 1 page, so they should be able to fill it out right after talking to your loved one. But from there, they need sort of a second opinion to declare that the patient is gravely disabled. So then they would either give it to, usually it's the medical doctor or another doctor, licensed doctor at the facility, if your loved one is at a facility. Read it over, review the charts, also do maybe an interview with your loved one, and then sign secondarily, right? Because you just don't want one doctor's opinion when you're taking something to court. So that's why the physician's declaration requires 2 doctors to sign, 2 licensed doctors.
I'm just going to add something real quick. It used to be in Los Angeles, they would only have 1 doctor sign, and that was sufficient. So this one young man went to court and he says, oh no, he knew his rights, and he says, you have to have 2 doctors. So there was a doctor at the court, there usually is. They got the other doctor to evaluate him and sign it. So that changed. All of a sudden, we were getting 2 doctors now.
Well,
Yeah.
one of the things that I would add too is basically when you get your conservatorship of your conservatee, if you look at the court papers, it tells you when you are to renew, and you need to put that on a calendar somewhere because you can't rely on the courts, to get this renewal notice to you. Don't rely on them. If within 3 months you haven't heard from anyone, just initiate that on your own. Reach out to the courts and let them know you are needing the declaration forms. Get the declaration forms, initiate that on your own with the doctors, have them signed it off. And if both doctors signed it, then just take it right on down to the courts and get a court date set up. And they'll put it out, the 3 months, but don't wait till the last minute. I've had families tell me that they forgot and they did this at the last minute, and the hearing was like a couple of days after the expiration of the conservatorship, and the courts allowed them then to meet 3 days after, and sometimes 2 weeks after. There used to be a concern of the various attorneys in court that said, gosh, we haven't hit a case yet where somebody actually goes over past the date, and what is the public defender's office going to do? Are they going to declare the LPS as to be null and void at that point in time because it wasn't renewed? But here in Orange County, they absolutely will retain the conservatorship until the hearing date, even if it runs past the end of it.
Yeah, in Los Angeles, once that date is done and you haven't requested the renewal and done all the work that you needed to do, the public defenders for the patient will say, no, it's over with, and that's it. Unless they've changed that, Shaylin. I mean, can you?
No, they haven't. They scroll and, every single page they're looking for it to this termination of date. Beyond the date, termination by law. Excuse me, that's what it's called. Termination
in Orange
by law.
County, what I'm actually trying to get across is that the application for renewal was made before it actually expired, and so the courts will try to get it as soon as they can, but it may be past the end of the contract with the courts, or the conservatorship papers. So they will keep it, they will retain it as active. They will not dismiss it. But you have to apply before it expires. If you've done nothing, it's over.
Okay. Yeah, so if you haven't requested to renew the conservatorship and got the physician's declaration, the closer to the end of the termination, you run the risk of the court dismissing it, the petition altogether, based on the legal technicality that it wasn't done on time.
Correct. Okay, next slide.
And it's 1 year. I saw somebody pop up every year, every 1 calendar year. So every 9 months or so, you better start getting your paperwork in order for the renewal, as far as getting that doctor to sign the physician's declaration and filing for the renewal for a hearing date.
Okay. Shaylin?
Yes. So grave disability, gravely disabled. What the basis of LPS conservatorship? It's legally what grave disability is. So it's unable to provide basic needs due to a mental illness of food, clothing, and shelter, or address basic needs for safety and health risk. But this definition is also expanding. I do want to, bring that portion up due to in January because of the SB 43 expansion of the definition of grave disability. So that will expand to substance use disorders and co-occurring disorders, and then that will as well as mental illness. So it can be one of the three or all three. Co-occurring is both. So
as well as
still medical. Go ahead, Gail. Yes.
No, as well as medical.
Yes, as well as medical. And it is food, clothing, and shelter, and medical as well will be added. So we're getting pretty close to, we're starting to have more trainings with DMH and within DMH to start expanding that definition and what it will look like when a conservator, when public guardian is doing investigations for conservatorship, as we're receiving referrals from them, from the courts and from the hospitals as well about conservatorship.
Okay, and that once they change that, we still have the same problem of getting the doctors to initiate the LPSs, because They just refuse to. And the reason why, uh, if it's a private hospital and they initiate the LPS and they get the LPS, now they have to place the person in a treatment facility, and the hospital has to hold the person to have a facility to put them in. Well, as long as they're in the hospital, that's acute care. Once the doctor writes it up and says, okay, this person's ready for subacute, they lose their funding for the person. They're not being paid by Medi-Cal or Medicare for that particular person. So if they're holding them for 4 months, they're losing a lot of money. That's one of the reasons why they fight so hard against LPS conservatorship. And the law is when the doctor or the hospital discharges a person, a mentally ill person, to the street, they are not held liable criminally or anything else for that person. So they can discharge a person who's very, very ill. There's not a darn thing you can do about it, because that's the California law.
Yeah.
So
I just really quickly want to provide the entire definition, right? So as of January 1st, the LPS Act's definition for gravely disabled is now going to be defined as a condition in which a person, as a result of a mental health disorder, a severe substance use disorder, or a co-occurring mental health disorder and a severe substance use disorder, both of those together, is unable to provide for their basic personal needs for food, clothing, shelter, personal safety, or necessary medical care.
And that's a good definition. It's now we've got to get people to implement it and use it, yes, which is my concern when that time comes. Okay, yes. Next slide.
So conservators court renewal, the court hearing process. So if a conservatee is noticed that they are going to have an upcoming renewal or reappointment hearing, and they speak to their public defender and they are not in agreement with the conservatorship continuing, both them and their public defender can either request a court hearing where the judge hears all of the evidence for grave disability. So the judge hears all the facts and decides if the person should be conserved for another year or not. Or they can make the option for a jury trial. And it's the same with every other kind of trial that has 12 jurors on it. They pull jurors the same way from those that are called for jury duty. And then those 12, that group of 12, will hear all of the evidence and hear all of the arguments. It may be more than one hearing date. And then they will take a vote and make a decision if the conservatee remains gravely disabled and should be conserved for another calendar year. But the court hearing and the jury trial are only occurring if the conservatee is not willing to submit for conservatorship. They say, absolutely not, I don't want to be conserved again. If they are in agreement, then the conservatorship just go ahead and go through by the judge signing off. Yeah. But they do have this right, so they may request it every single year, and it may span some months from all the court hearing dates.
If I can just add, if you have a jury trial, it's very distressful. It really is. And when you're picking the jurors, you want to be cautious not to have a Scientologist, because they do not believe in involuntary mental health treatment. But you cannot ask, are you a Scientologist? So you have to have questions that you can ask to kind of pick out whether somebody would be in that realm. And I think I'd be a little bit cautious of the people with the spiked hair, that the piercings and all that. I mean, they tend to be more liberal. So it's very difficult. You have to convince all 12 people. And in California, that's hard to convince 12 people of anything. So good luck on that. It is.
Yeah, I really think it's very difficult for them a lot of jurors to understand what exactly conservatorship is and the benefits of it. because it's temporary. It's only a year that we're talking at that particular time.
Mhm.
But yeah, jurors take a lot more convincing because they're not like the judge sitting hearing the cases of it and the examples of it all day.
Right. Next slide.
So what if the conservatee goes AWOL? You want to file a missing persons report. I'll skip down and I'll skip back up again. If you're going to file a missing persons report, you want to make sure that you go to outpostforhope.org, and they have some really excellent training and insight into how to go about all of that. You want to give a copy of your conservatorship papers to the police. Any person with a serious mental illness goes to the top of the missing persons list under missing children, as dependent adult does not need to be under conservatorship. If your loved one's on a conservatorship and you report them as missing, there's no waiting period. That will be put into effect immediately. They're required by law, the police officers, police department rather, are required to immediately initiate the proceedings that involves all of that. You know, there's a special website that they have to post to. They have to put it out to the cars that are out in the community to be on the look for this individual and so forth. So again, Outpost for Hope is an organization that I have found amazing. Unfortunately, they've taken down some of their information, but the gal that runs it, Gail, lives out in Florida by you. She's just on the other side of the peninsula, I guess, as you would call it, in Florida. And she's actually gone out and trained a lot of police departments. So you'll find that the information that's in this website is incredibly valuable for anybody that's dealing with a missing persons. So Gail, is there anything you want to throw in there?
Yes, I do. If you filed the missing persons report and your loved one's not under the conservatorship, if they're under the conservatorship, the police will, when they find them, if they find them, will say, what do you want us to do? And you can say, take them to the hospital or something like that. But if they're not under the hospital, under the LPS, they can contact you and they say, okay, we found them, they're okay. Well, that's not going to quite cut it for you. So what you can do, they cannot tell you where they are because they claim HIPAA. But what you can do is say to the police, oh, thank you so much. I really appreciate this. I'd like to get you a cup of coffee. Can you tell me where you're at so I can call in and have, like, for breakfast or lunch or dinner, to pay for you to be able to go and get, you know, coffee, whatever it is that you want to get them. Can you tell me where you are? If they can tell you where they are, and they usually are pretty good about that, and they'll say, well, you know, you don't have to do that, but we are at, you know, they can tell you that. And many times they will. So now you have the general idea where your loved one is, and you can go over to that place. And don't let your loved one find you, because if they see you, they're gone. But you can wait for them to jaywalk or do anything that you can call and have them put in the hospital. But don't let them see you, because I will tell you, if they see you, they're gone. Unless you have a rapport with them that you can say, meet me for lunch or something like that. That would be helpful. Okay.
So I will add another part of that, and that is that basically there are families across all of America, some of which have found outpostforhope.org, and one of the families reached out to them, who in turn referred that family from Arizona to me, because the last report that the family had was that their loved one was out here in the Orange County area. And so we got involved with this family. We got involved with the police, finally got a missing persons report filed. Anaheim PD didn't want to do it. I had to get another chief from another police department to come back and tell them, yes, you have to do it. You have to. So we got that filed. They found the son up in the Los Angeles area. He was at a McDonald's because he was acting a little bit off, and the police came out. discovered he was on a missing persons report from Arizona. They contacted the office, who then contacted the mother and said, we have your son out here at this address at the McDonald's, and therefore now that you know where he is, he's no longer missing, and we're taking him off the missing persons report. And that's just disastrous. So I don't have a fix for that, but it's something that we have to deal with. So many police departments aren't going to really work with you. I think that Gail's suggestion is great. I don't know if the police will always go along with that or not, because I've found some less than appropriate responses from police departments. But do what you can. Go to Outpost for Hope. Outpost for Hope. It is probably your only hope when they go missing. All right.
Okay, next slide. Shaylin?
Shaylin?
Did we lose Shaylin?
So no, I'm here. Hi. Leaving the state of California. So LPS conservatorship is very specific law for the state of California, right? So if you have conservatorship over someone, you must notify the courts if you're going to take them out of the state, right? Especially for an extended period, because you kind of want to have some kind of notice to protect your right as far as conservator. The California presently does not have reciprocity with other states. So you can't, we're moving to Arizona, for example, we're just going to transfer conservatorship there. Arizona, whatever county you're moving to, may not decide to open an investigation and accept all the information from Los Angeles County to establish a conservatorship or guardianship, whatever they call it there, when you're moving. So you just want to be very careful of that. Also with the elopement and AWOLs, if they're make it for some strange reason out of the state, it is exceedingly difficult to find a lot of legal and police presence and support of getting them back to California, because a lot of places and a lot of cops and things just kind of look at it like, oh, well, they're over 18. They're not understanding the disability and the work that it was to establish the conservatorship, and also a respecting of it. They're just looking at a piece of paper that with legal jargon that they don't exactly and entirely understand. So it is very important that you kind of notice either your attorney or someone at the court to let them know that you'll be gone, and gone for about how long, just so you have some kind of support.
Mm-hmm. The other thing is, when you're looking at another state, planning to move to another state or something, LPS is specific for California. Look up involuntary mental health treatment in these other states and the terminology that they would use for that. The other thing is, like, some states use conservatorship, some states use a guardianship. Florida, we have Baker's Act reform. That's for your involuntary mental health treatment. They have different terminology. You do not want in California a guardianship. A guardianship, you are now liable for whatever that person does or doesn't do, or whatever their bills are. Your LPS, remember we mentioned that at the beginning, you are not liable financially, criminally, or anything for whatever that person does or doesn't do. So you don't want a guardianship in California. That would not be to your advantage. Okay, Jim?
I, again, think you are just expert in addressing that. So let me talk about this slide here on 43. I'm sorry, because I should not look at the chat. I get so sidetracked. It's horrible. Thank you for your determination. And we want to thank all of you for coming today. You know, all of us, including Gail and I and everybody else, we have our good days and we have our bad days. You know, we have times when things go well and other times when you can't sleep at night. So with that being said, when you think you've had enough and you're just at wit's end and you can't deal with this any longer, and you think you've had enough, you can still give 10% more. That's the Navy SEALs model, but yet the Navy SEALs haven't walked in our shoes or walked our road. It's really something that people outside of the mental health arena just don't even begin to comprehend. So you want to keep strong, take care of yourself. You're your loved one's strongest chance for recovery. You want to stay strong, because if you go down and just can't do this anymore, who's going to be there? It's kind of like, you're in the airplane and all of a sudden a window blows out and there's no oxygen. You want to take care of your little kid next to you. First, no, you put the mask on yourself so that you don't pass out, and then you put the mask on the kid. And it's the same concept for mental health. You want to keep yourself strong. You want to make sure that you're not passing out, you might say, and that you're there no matter how bad and how rough it gets. You're there for your loved ones. One of my newsletters that I put out was on a product called Inositol. I think it's Inosotol or something like that. And it's really good at just taking the edge. It's over the counter. It's not an antidepressant, but it sure does deal with the funk, and it really does help you get through the day sometimes. So you might look into that at a health food store. I'm not prescribing it, okay, but it certainly works for my wife and myself. So that being said, forward and onward. Gail, you want to add in anything on this?
No, I think you did a good job. Great.
Next slide.
Right.
Shailene, did you have something?
How did we get the?
Oh, no, I didn't.
Oh, okay. Actually, Jim, this should be your slide.
Oh, but Gail, it has a G first.
I'm changing that one. Jim and I both, we hate asking for money, but actually, we're going to ask you if you wouldn't mind donating to NAMI Urban LA. But please note that this is for the LPS Conservatorship program, because otherwise it goes into the general fund. And we could use a little bit of money every now and then. I don't like to ask, but every now and then our funds get a little bit low, and we need it to continue this program. So we trying to get Araceli to do more Spanish programs in this. Right. So we're working on it. But if you can't donate, if it's a problem or you're tight on money, please do not donate. Only if you've got the funds to be able to. So anyway, okay, thank you all for coming.
And I might add, Gail, that one of the things I've started doing is when families in crisis call me and I've helped them and they're so thankful for what I do, I ask them to at least consider donating to NAMI, even though it's out of county. Consider donating, because it helps support these meetings and it helps so many other families. And I know for sure one or some have done that. I don't know how many, but that's something that for those that can afford to do that, it's always a tax write-off. They're nonprofits, so take advantage of that. And thank you all for coming as well.
Thank you. Yeah.